Good afternoon, ladies and gentlemen. Good afternoon, ladies and gentlemen, and welcome to today's webinar. We continue exploring the provisions of the ZIHRM Act number 3 of 2022, and I am your host and the Council Secretary for the Zambian Institute of Human Resource Management. We have maintained the discussants from the last discussion. So allow me to introduce the discussants again for the benefit of those that may have missed the last discussion. We introduce first Council Mujuda, who is a representative of the Attorney General and sits on the 14th Council of the Zambian Institute of Human Resource Management. Council, kindly say hi to our audience today.
Good afternoon, everybody, and I hope everybody's keeping warm. Osaka is cold.
You can say that again. All right. Allow me to also introduce Council Ulaya, who is Assistant Labor Commissioner Legal under the Ministry of Labor. Council, kindly greet our audience today.
Sorry. Trying to turn on the video as well. Hello, everyone. Hope you are having a nice Friday. My Friday has come too early, too quickly. But you can see I am in the car, I am in the world. So, but I'll be able to concentrate and deliver to your expectation and hopefully above expectation also. Thank you.
Exceeding expectations sounds good. All right. And last but not the least, allow me to introduce the CEO and Registrar of the Zambian Institute of Human Resource Management, who's also discussed on this afternoon, Mr. Owen Sikatumba Chilala. I'm always confused about which one is his last name. I hope I've put his names in the correct order. May you greet the audience this afternoon, sir.
Thank you, CS. Greetings, everyone. I look forward to a great interaction this afternoon. Thank you.
All right, so we will pick up the conversation and discussion this afternoon with a focus on part 4 and part 5 of the ZIHRM Act. And these two parts basically focus on disciplinary provisions as well as provisions that relate to the inspectorate. And so what we'll be looking at this afternoon will be how, the provisions have been laid out and how this will impact, the institute and impact individual members, impact the public as well, amongst other stakeholders. And in discussing this, we will try to draw reference to, some cases that may have been decided in the courts that leverage on provisions that are very similar to the provisions that we have in the ZIHRM Act. And I think that Council Mujuda will try and lead us into one case particularly that will basically highlight a few salient issues that very, very similar to what we have under the ZIHRM Act, arising from a matter that arose under the laws, the Law Association of Zambia provisions. And so to just recap, we've already looked at part 1 and very, very critical there to understand was the definition of HR. We've looked at part 2, which focuses on the institute. Part 2 looks at the constitution of council, the functions of the institute, amongst other provisions. And then we also look at part 3, which primarily focuses on provisions that look at who a practitioner is and who a member is and who qualifies to be a practitioner, who qualifies to be a member, and how information and data that pertains to practitioners and members is supposed to be managed, etc., etc. And today we tend to look at the provisions of part 4 and part 5, like earlier indicated, and key focus is going to be obviously on what the salient issues are there. We recommend, as always, that you may at this stage just pull your act and then let's see if we could follow the provisions together. Let's begin our discussion this afternoon with the very first provision under Part 4, which basically talks about the fact that there is going to be a disciplinary committee, and that there's going to be a professional conduct committee as well. What's the difference between these two committees? We could have Council Laya start, and then we can build on from there.
Yes, just go over your question again. I was looking at my act when you were talking.
Okay.
I know you've asked about the difference between two committees, but which ones in particular?
Yeah, so the PCC as well as the DC.
Oh, right. Okay, so you've dealt right into it. So in terms of setting a sort of like background to what this part is talking about and our discussion today, we are looking at a very, very critical component in the regulation of HR practitioners. And this is the part that is hoping to encourage good ethical behavior, if I may put it that way, in the hope that we will not have any of the practitioners falling foul and being brought before the disciplinary mechanisms that are enshrined in the Act. So without going into the details of what the other provisions are saying, in answering the question specifically, when discipline is invoked against a practitioner, the Act is envisaging two avenues. The first one is through the provincial, what are we calling them? I've been saying PCC for the longest time, the professional conduct committees. So these ones will be set up in all of the provinces. I think that is why I carelessly called it a provincial one, because we want to have a committee of HR practitioners, your peers in your province, who understand the peculiar circumstances perhaps that prevail in that particular province, to hear you, right? Instead of matters all being referred to the main disciplinary committee, which will be situated in the capital in Lusaka. So the professional conduct committee is one route through which you will be given an opportunity to be heard. So I'm not looking at it from the angle of them meting out discipline on you as a practitioner, but this is a forum that will be available to you as a practitioner for any allegation that might arise. So the allegation might be false even, because under our legal system, we go by a presumption that you are innocent until you are proven guilty. And that presumption or that principle will apply in this particular case. So when there's a complaint against a practitioner or an allegation against a practitioner, one route will be to go through this professional conduct committee. There will be ad hoc ones that the council will set up for each particular province. And it will comprise 3 practitioners in the particular area where this ad hoc committee is set up. And some legal counsel will also be on those committees. Now, the primary function of this PCC is to vet, the complaints that are brought against practitioners. So they'll also not only be able to vet, but they'll also have power to hear matters. They have powers under the law to impose some sanctions, including a suspension of up to 12 months. Now, when the PCC has made a decision and the practitioner is not happy, the other party is not happy, the matter can be escalated to the disciplinary committee, which is the main body that will be reposed with the function of meting out discipline. So before I finish Council Malandula's questions, let me not go into great detail at this particular point. Let me just say the PCC is the step one before you get to the disciplinary committee. So the difference is that the PCC are ad hoc committees set up in the provinces to hear disciplinary matters and to vet to see which ones are frivolous, which ones have merit, which ones don't have merit. The disciplinary committee is the main committee that hears disciplinary cases that are coming to it from the PCCs. Let me end there for now.
All right, thank you so much. Let's then take a few steps back now, since we've talked about the structures that are in place to be able to look into issues of discipline. What qualifies to be misconduct in accordance with the Act? And how does the code of ethics come into play? And maybe let's talk about what qualifies to be misconduct first, and then we could also talk about the process through which the code of ethics is to be, brought to afford, and does it carry the, authority of the law? Is there chance that it could be contested? Yeah. Let's start with what qualifies as misconduct according to the Act, and then we look at the code of ethics. Registrar, would you like to lead the discussions, and then maybe Councillor Mujuda can fill in the blanks if there'll be any.
Thank you so much for that very wonderful question. Thank you, Councillor Ulaya, for that clarity on the two very prominent committees of this Act. So misconduct is twofold, pursuant to Section 36. You will note that the law uses the term contravention of this Act directly. That is to mean there are provisions here in the Act that a practitioner can breach, and that will be misconduct. That would warrant them being brought before the PCC or the disciplinary committee itself. That's the first part. The second part is with an understanding that the law cannot exhaustively list everything here and say this is an offense, this is what, this is misconduct. So with that in mind, the drafting principle then delegates. So in this instance, the law has delegated to council to come up with a code of ethics. So a code of ethics will define. You will understand that regulation is to direct some certain behavior. So in that code, the anticipation is that there will be prescription of expected behavior, and then departure from that behavior then constitutes misconduct. So either by implication, when one departs from the prescribed behavior, or by listing certain things that are not expected of a practitioner, the code will do that. And so a breach on those then constitutes misconduct. Now, the second part of the question was to deal with whether issues that arise from the code of ethics have the weight of the law. Wow. We will say so because the law has delegated, and it is that same document that will bring you before the committee. So there's no escape there. Thank you so much, CS.
Thank you so much. What would be the state of things, Registrar? Maybe just before you you know, step away from the floor. What would be the state of things? We do have a code of conduct right now as an institute. Is that code of conduct enforceable in light of the change in the law? What would be the guidance to the members this afternoon? And if it is, how can they access it and where would it be found?
Thank you so much. We will hasten to say that even in the repealed law, there was the code of ethics enforceable. And what has happened now is a strong and serious reinforcement of that code. Now, as to whether it was an initiative outside, it was in place. But now we're grateful that the law expressly put it so. So what the position is that certain matters, before they are amended or repealed from the old law, they are working. We'll borrow the principle of the SIs, the way they work. Until when there's an SI which directly replaces that particular SI, it will be standing. So we have a code of ethics, which is in place. Of course, due revision now or amendment, whatever term we want to use. In terms of accessibility, it's been circulated, it's on our website. Those that want hard copies, we have hard copies at the Institute. You remember most events that we go to the AGM, we carry these books. Those that want, they do access and get. So that's where we are currently. But I will strongly mention that it is in their need of revision to accommodate the changes, the many changes that have occurred in the profession over the years, and also to make it more stronger so that we don't mess up the profession. It must be very serious. Thank you so much.
Right. Thank you so much, Registrar. Councillor Mujud, I'd like you to discuss the composition of the disciplinary committee and the authority that the disciplinary committee has. And obviously, in I think addressing that, we could also look at why it may be seen to be prudent that there should be a person who is a legal practitioner of standing that is at the same level of a judge to chair that disciplinary committee. And obviously the representation, the participation of LAS as well on these particular committees, what would be the significance of that?
Thank you, CS. And Section 41 of the Act provides for the composition of the disciplinary committee, and it provides for one of the things provides that there shall be 4 practitioners. The practitioner, these are human resource practitioners, but then it also provides that there will be the chair and the vice president shall be lawyers. And what else? And then being lawyers, obviously would be coming from the legal profession in terms of that. And one of the things that you would like to get is that the proceedings of the disciplinary committee to a large extent would be almost like a court sitting. And that is why even when people will be appearing before the disciplinary committee, they will have the right to appear with a legal representative. So that is why they have said that the chair and the vice president, and even when you look at the standing of those two people, their standing has to be above 10 years, which means that these are people who are capable of being lawyers. So the care that has been given to ensure that there's fairness, there's justice, that people will be appearing before the committee receive maximum fairness. I think the act has taken care of that one by ensuring that at least these people would be of a good standing, and then they would be understanding the law. And maybe I think during introductions, you also mentioned that I was going to touch on some case law, and then I was going to also just try to give some perspective, some context in which I think you had asked Council Laya to give an example of, to give the difference between the PCC and the disciplinary committee. In this case, I'll refer to the case that you talked about was the case involving Arnold Chikoli. I think it's a recent case where a lawyer was struck off the roll. This matter involved some client of Mr. Chikoli lodged a complaint with LAS that he had not honored some money transaction with him. So LAS referred this matter to the Legal Practitioners Committee. And when you look at the Legal Practitioners Committee, that is to a larger extent, you do look at it, I think the role that it did was almost like the way the PCC operated. So they heard the matter of Mr. Chikoli, and then they found that Mr. Chikoli indeed they found that there was a prima facie case, and they suspended Mr. Chikoli. This was despite the fact that the original complainant in the matter withdrew the case. So, but LAS still went ahead, the Legal Practitioner Committee still went ahead and had the case. After suspending him, they referred the matter to the LAS Disciplinary Committee. The LAS Disciplinary Committee also, regardless of the fact that he had settled the matter amicably with the complainant, they still went ahead and found that indeed Mr. Chikoli had acted dishonestly, and they recommended the matter that it goes to they recommended the matter to the High Court that Mr. Chikoli be struck off the roll. So Mr. Chikoli, the court then made a finding that indeed Mr. Chikoli had breached the law and had acted unethically, and he decided that he be struck off the roll. Now, when you look at the powers of the disciplinary committee of the ZIHRM Act, what it gives the disciplinary committee the powers to actually recommend the cancellation of the practice certificate of the practitioner. Now, I've been trying to check to see whether the same system would suffice where the matter would have to be sent to the court, but I don't find that. So it seems that on the cancellation of somebody's act, that would stand with the disciplinary committee. We may not get to the court, but that it is through the appeals process that one would get to the court. And remember last time when we spoke about also the differences between the Legal Practitioner Committee and the Disciplinary Committee, it also entails the appeals process that one would have to go through. where the PCC has recommended, has meted out its punishment. If somebody is aggrieved, first of all, they would have to appeal to the disciplinary committee. And if they are not dissatisfied with the holding of the disciplinary committee, they would have to appeal to the High Court. Now, there's been quite some confusion, I think, in the past. You find some people would come to, there are some lawyers have been bringing up cases to the court through judicial review. And I think this is one thing that practitioners would need to also remind their lawyers in the event that their lawyers want to bring it through judicial review. That would be a wrong process. I think the Act does provide that people would have to, it will be by appeal to the High Court. Similarly, where the institute has meted out an action on a practitioner, the appeal would be through to the minister, from the minister to the High Court. I hope I didn't digress so much, but I just wanted to touch on the case that the CS had asked me to touch. Thank you.
All right, thank you so much, Councillor Mujuda. Councillor Ulaya, I'd like your comment on the difference that Councillor Mujuda just highlighted between the process that is referred to under the, I think, LAS provisions versus the process in the ZIHRM Act. In the event that the disciplinary committee made a decision to cancel someone's practicing certificate, in the case of Chikoli, that issue needed to go to the High Court first before that could take effect. In the case of ZIHRM, what is your interpretation of what the provisions would require? Would there be need for the matter to first be presented before the High Court before the cancellation could take effect? Or is the decision of the disciplinary committee final in that particular sense unless a practitioner appeals against the decision? Your thoughts, Councillor Ulaya? Councillor Ulaya, are you there?
I think she has dropped out. She's trying to log in. She will be on in a few.
All right. Registrar, would you want to give your thoughts to that question?
Thank you so much. I think well explained by Councillor Mujuda that the appeal for us lies through the minister, and then from the minister it goes to the High Court, to be specific, not just the court, but the High Court. Is similar. Apart, the only departure is that the diversion to the minister. With LAS, it goes straight to the High Court. And as rightly pointed out, not in form of a judicial review, because I think we may not delve into those laws. That mistake he was explaining, people confuse administrative law. Judicial officers and the like, or public officers, are the ones who can go the route of judicial review. But in this instance, the law has prescribed into the High Court as a way of appealing the decision that has been made. Thank you. Riding on that, I think I see consistently the need to expand on where Councillor Ulaya ended with the difference between the PCC and the disciplinary committee. She explained very well. We just need to emphasize that there are so many areas of difference. One of it is, as observable, by assumption. Of course, the law has not located where the disciplinary committee will be, but it can be assumed and construed that it's centrally here because it's a national disciplinary committee. It's the main one. Whereas the PCC, they've been dubbed ad hoc and sent to the provinces and eventually to the districts. And I think the anticipation of the law there was the efficiency and speed dealing with matters local where people are. That's one. The second one, you will note the composition of these two committees. That whereas there's a legal representative from LAS mentioned in the PCC, it does not specify that that person will be chairperson of the PCC. It says members who elect the chairperson. When you come to the disciplinary committee, you discover that the chair and the vice have been given to the legal people. Why is it so? It is the magnitude of the sanctions that that's another difference. I'm moving to the third difference. The magnitude of the sanctions these two committees can give. The disciplinary is the ultimate, and what it does actually can kill off your career in HR. Once they've cancelled, they are literally saying you will not practice in your life. Now, to safeguard that, the other difference is that you will see that there is mention for the disciplinary committee that the proceedings will be held in camera. That is not the case with the other committee. It has also emphasized that the proceedings of the disciplinary committee will be by a way of a reasoned judgment. It follows that if you are not legal, you may not do that reasoned judgment. And to aggravate the matter, you will note that not any lawyer would do a reasoned judgment. They have then specified at what level of standing that lawyer should be. So that's the seriousness of the DC there in explaining its powers. You will note also that the sanctions now, dealing with the sanctions in the PCC, they can only suspend if they found you guilty up to 1 year, 12 months. The DC goes above that to an extent of canceling. You know that the PCC cannot cancel a certificate. They can only suspend. So that's another difference. The other last difference I'll give is that this PCC is more like an initial process leading to the DC. There's a part of investigation, the way we do preliminary investigation to see whether there is a case which we can put someone on trial. And then if they found that there is something, they can recommend to the DC now to put someone on trial. So those are the differences that we should see. But as a way of emphasis, it is never a good thing to appear on either of these. Whether it be PCC or DC, if you have an opportunity to stay away, practitioners, do stay away and do the right thing. I want to retake the question that you started with on my part. When we said what constitutes misconduct, I did allude to the fact that breach of certain sections in this act and that which will be in the code of ethics. There's just one which I want to highlight, which has been put in the act, where members, if we glossed over it, they may not take it serious, yet it's very serious. So in terms of section 33, 34 8B is very serious. Unlawfully discloses or uses to the practitioner's advantage any information acquired in the practice of the practitioner. I bring this because we have a true case right now as we sit. I'm dealing with this. There's an accusation of this right now in my office. Now, you will note that as practitioners, we are custodian of very sensitive information, and it will always come to us as a way of, by virtue of us holding those offices. Now, the misuse of such information constitute a very serious misconduct professionally. And we want to, I wouldn't say warn, yes, it's warn, but alert our practitioners out there, make sure you use correctly the information that you acquire by virtue of you being a practitioner, human resource practitioner, because the abuse, the misuse, the misapplication will land you into problems. Let me end here for now. Yes, thank you so much.
If I could just, CS, if I could just add to the what the registrar was referring to, if I may.
Please proceed, Councillor.
Okay, this is regarding the composition of the PCC, especially the chairmanship of the PCC. The Act actually does provide that under Section 36(2), it provides that the members shall elect the chairperson and vice chairperson among the persons referred to under subsection 1A. And under subsection 1A, that is not, it talks of not more than 4 members who are registered as practitioners. So this, the chairperson, vice and chairperson of the PCC will be elected among those 4 practitioners, registered practitioners. Thank you. I thought I just said that would be the difference with the disciplinary committee, which is categorically stated that these would be lawyers. But as opposed to the PCC, these would be practitioners. Thank you.
All right. Maybe just. Sorry, did you still want to make a comment, Councillor?
No, I just want to clarify that these, when you say practitioners, these are human resource practitioners, not legal practitioners under the PCC. Yes.
All right. Okay. Thank you. Thank you so much for that. For that qualification. Councillor Laya, there was a question that I wanted you to attend to. Can you hear me now?
Yes, I can. And apologies, I don't know. I'm having challenges with connectivity. And
okay.
Maybe my son has finished my bundles. He had my phone before this. I had properly juiced it up, but you know how these kids can go through data. Yeah.
All right.
So I have commandeered my husband's phone, and shame, poor man. Yeah.
Oh my. Okay. All right. All right. So the question I wanted you to attend to was in respect to the case that Council Mujuda shared concerning one legal practitioner, Chikola, who was struck off the roll of practitioners under the Law Association of Zambia. One particular issue that I wanted you to comment on was the process that was followed under the Law Association of Zambia was such that after the disciplinary committee found the practitioner guilty, the matter needed to go to a high court before the person could be struck off the roll. Whereas the disciplinary provisions under ZIHRM do not directly describe that should be the process. So where the disciplinary committee, for example, finds one, guilty of a certain offense, it seems that the Act has given mandate to the, committee to be able to, recommend the cancellation of, is it recommend or actually cancel the cancel the certificate of practice for a practitioner. What would your comment be? Is this process the way we've described it, or is it supposed to be in the way that it is managed under the Law Association of Zambia provisions?
All right. So the processes that relate to discipline for legal practitioners and human resource practitioners at that particular point differ. That is where the divergence occurs. So for both professions, there is an element of a hearing provided to the practitioner by a select committee. And when they are found guilty, LAS also does suspend advocates. But the principal difference with legal practitioners is that we are first and foremost referred to or known or required to be officers of court, all right? So much so that even when you do get instructions from a client and there are all those issues of confidentiality, you have a duty of care, the overarching or the overriding interest of a lawyer should be towards justice. And that is why they are also known as officers of court. So when a lawyer is, he is admitted to the bar, that bar is in the courtroom, okay? There are different, when people come, they just see benches where lawyers sit. That is called that is called the bar. And when you attain a certain level of proficiency, excellence, you are then called to become state counsel. You sit on certain benches. So when you are a legal practitioner, you cannot go and sit in a place where state counsel sits. And apart from being a member of LAS, you go to LAS, you pay money, you become a member. You also must file in papers at court so that you are now entered in a role, when the Chief Justice calls you. So it is because of this special role that lawyers have where they are considered as officers of court, and you are entered onto a role that is in the that sits in court. It then follows that when LAS has, the disciplinary committee there has found you guilty of such gross professional misconduct, they will then make an application to court for the court to consider you to be struck off the roll. So they will get all that evidence, and then that process at court will also go through. And if the court also finds that, yes, indeed, this is very, very gross misconduct, then they will strike you off the roll. That is not necessary for HR practitioners because they are not officers of court. So that is the distinction. So as it is, the process is sufficient. I think care will be taken in ensuring that the practitioners that are sitting, both HR practitioners and legal practitioners that are giving erring practitioners an opportunity to be heard, will be of such clout that they'll be able to, sift through the evidence and give a verdict, whether of guilty or not guilty, that could actually even stand the test of any court case in case somebody decided to appeal. Thank you.
All right. Councilor Mujuda mentioned earlier that the appeal, when a member wants to appeal against a decision of the disciplinary committee, the appeal line is to the High Court directly, and that in itself seems to infer that there's supposed to be a certain level of separation of power between the council of the institute and the disciplinary committee in that particular respect. To what extent could council impact the decisions of a disciplinary committee? Is that possible under the current provisions? Is the disciplinary committee autonomous to the level that they are independent of any influence of, say, council, which is the highest governing body of the institute, second to obviously the AGM? Councillor Ulaya, would you want to comment on that?
So for a moment, I was lost because I wasn't so sure whether you were referring to council as in COUNCL or council with
the council of the
CIL.
institute.
So I was, so it is the body. Yeah, no, now,
The body, yes.
Yes. Now, having clarified that, ask me the question now.
Can the council, which is the highest governing body of the institute, have any influence over the operations of the disciplinary committee? Or will the operations of the disciplinary committee be independent of any influence from council and or secretariat of the institute?
Okay, I think I hear you. The disciplinary committee has to be independent if they have to give practitioners an impartial hearing. But they are administratively, they will not totally be independent of council because they might require a secretary of services from secretariat. They will be appointed by the council itself to sit on that particular committee. So in that particular instance, the council will have a say on who is sitting on the disciplinary committee. But when it comes to the actual adjudication, the actual hearing of the matter, it is required that the council does not prejudice or influence the persons that are sitting on the committee to take a particular position. Otherwise, then, a practitioner would have a cause of action to appeal to the court for bias and for not being afforded an opportunity for a fair hearing. So in terms of its operations, they will have to rely on council. But for purposes of the hearing, they will have to be independent of the council. Thank you.
All right. And what will qualify to be hearing in this case? Could a complaint being raised against a practitioner and a practitioner giving their response amount to a hearing, or would that actually need to be an actual physical meeting that takes place for there to be considered to have been a hearing? Councillor Lai, you could go first, and then maybe Councillor Mjuda could comment on that as well.
All right. So the process of discipline, I'm sure when I dropped off was expounded on a bit, I am hoping. But the process of discipline as it has been envisaged or captured in this act is that either the institute itself on its own motion can institute an investigation into some activity that might involve requiring people to say something. You can write to somebody and say, okay, can you explain yourself a little bit on this issue? And then the person can give what we are accustomed to as an exculpatory letter. And based on what the person has explained, then you can make an informed decision as to whether you want to now go to the next stage, which is an actual hearing. Now, the hearing itself can be physical, it can be virtual. Sometimes on the basis of what the person has said in the exculpation, you can actually make a decision because their explanation is maybe an admission or not attacking the evidence in any way. But when you do have a hearing, this is where people are sitting either physically or virtually. And you might want to bring in witnesses and all. And it is that particular mechanism that you put in place that we call a hearing. So some cases will require a hearing, I suppose. And some cases, based on the exculpation that is given, it might be an admission and there might be no need to actually have a hearing at all. And especially if the person gives an exculpation and they say that they will not be bringing witnesses. You might decide you want to come and bring the person to come and say verbally what they have written, or you can make a decision based on what they have said in the letter. But when you go a step further beyond the exculpatory letter to afford a person to come in and give evidence orally, with or without witnesses, that is what we refer to as the hearing. Thank you.
All right, thank you so much. Councillor Mujuda, if you have any addition to that, and I'd also like you to address the role of the Chief Justice in setting, the procedures and the processes that the disciplinary committee is expected to be able to follow.
Thank you. And I think Councillor has ably tackled that part. And I think I will just go straight to the role of the Chief Justice. And the role of the Chief Justice is established under Section 47 of the Act. And it does empower the Chief Justice to issue a statutory instrument as regards to the rules relating to the disciplinary committee that they would follow. So the Chief Justice may set up to say the manner of and form of lodging the complaint, the manner of serving, how the summons would be, or is it summons or the complaints would be served on the accused persons or the people complained against, and the procedure that will be followed. So I think it was the involvement of the Chief Justice as a lawyer. I think it shows to me how serious the disciplinary committee will operate. I think it's very high, and like Councillor Ulaya pointed out, the clout of the people sitting on the disciplinary committee is expected to be quite high. And even independence, I think I expect to be the disciplinary committee to act with maximum independence when it comes to meting out sanctions, because it is the way the disciplinary committee operates could be a ground of appeal to the High Court. So the people who are in the committee, they will know very well that whatever they do, if they are going to prove biasness, they are going to show that they are being driven by counsel. When I say counsel, I'm talking of the 14th counsel, or is it 15th counsel, 16th counsel? That's what I'm referring to. So if the practitioner could actually appeal to say, this counsel was biased against me, or this is what it is. So I think members should be less assured that they will receive maximum justice, I think maximum fairness. And I think our courts have demonstrated fairness in terms of the way they will adjudicate on different matters. So I think for me, it should be a source of comfort to the practitioners. But like the registrar has said, practitioners should avoid. It is bad to get to the DC, to the PCC. It is worse to even get to the DC. And so practitioners should actually avoid it. I think when the CJ, Chief Justice, is involved, for me, I think it means quite a lot. Thank you.
All right, Registrar, before we move to part 5, which talks about the inspectorate, we have a provision under, this should be section 35, that speaks to a person lodging a complaint with the institute against a practitioner where that person alleges that the practitioner has contravened the code of ethics or any provision of this act. What modalities are in place, or what modalities will be in place to ensure that, one, the public is sensitized around this right that the public has, and also what modalities will be in place to ensure that there is a vehicle or an avenue through which the public can actually, register their complaints as provided for under Section 35.
Thank you so much, CS. Twofold. I'll speak to what is here now and prophetically how we envision the future. Because you know that from where we're talking, we have other documents yet to prescribe certain matters. And so those are the ones I'll say prophetically now. So currently, I'll start with a very difficult one, where we are, as an institute, also we can institute investigation into a matter. The vehicle there is through whistleblower in various avenues, where I know most cases there are people who, I always avoid to use the word coward, but who don't want to come in public, but I've already said that word anyway. They want to remain anonymous, but some of it is not being coward. Maybe they want to manage relationships in organization. It's acceptable. So you can write to us. If you want, slide the letter under the gate there when we are not there, like the long weekend coming, push it there, we'll find it, we may follow through. Right, as I said, I have a case. There was one courageous person, they brought a big dossier, which I have now, of allegation against our practitioner. Right, came to the office, I have a complaint, I've written all this evidence and this follow-up. That's the avenue. You can write to us via email. You can, now I need to check whether we have opened that, but we have discussed through the famous Glue Up, we have opened communities. So complaints and whatever, a community there, you can post certain things we can follow, provided we have an avenue to validate and investigate. That's the first part, where you want to remain anonymous. But right now, the law has specified that right to the institute through the registrar. If you have a complaint, write and bring to us. And then our job will be to forward it to the PCC, which will do the investigation and make a determination whether it will conclude within itself and give those prescribed sanctions, or it will escalate it to the DC for further and more serious sanctions. So those are the provisions that we have. Last time, I think Council Olaya did explain the principle in law of postage. So all avenues are available. Those that are far there, if my cousins down in Changombo there, they can't reach internet, they want to post, post will receive. Whether the law has prescribed within what period the complaint must be heard, there is also the rule in law about postage. It will be treated within time using that principle, provided we receive it and it would have followed the actual procedure. Let me rest from there. Yes, thank you.
All right, thank you so much. We have two questions before we move to the inspectorate. The first question is, good afternoon, Chair. Does ZIHRM have a constitution available? Where can members access this document? And I believe that should go to other documents like the Code of Ethics and probably the standards booklets that basically provide for different things that members would need to know. Registrar, kindly take this one. Where can members find copies of the Constitution, Code of Ethics, Code of Conduct, and whatever other documents that may, speak to the standards of practice and everything?
Thank you so much, yes. I'll clarify that some of them, those that are new, when we say governance documents, like the competence framework, not yet with us. The Constitution, as we've said, we are not starting afresh. The Institute has been in place from 1967 and then by Act from 1997. So the Code of Ethics is there on our website. The Constitution is there on our website. The Act itself, both if you want to do a comparative analysis of the old one, 11 of 97 is there. ZIHRM Act number 3 of 2022 is there on our website. So those can be accessed. We have already emphasized the point that the Constitution, the Code of Ethics are in their need of revision. And that process is ongoing as we talk. The ad hoc committees which have been set up to look into those matters. But currently those that we have from the old regime, they are with us at our website. I did mention to those that missed that, those that want copies, I wish I could drag one to show how it looks, but it's a booklet for Code of Ethics. It has a balance of scale like a judicial document. We have one. That's the document. You can come to the Secretariat if you want hard copy, whatever you want. Thank you so much.
Right, thank you. Registrar, another question is, will there be need for HR practitioners to register with or make known their presence to the district committee? E.g., if one is working in Lusaka and they change district of residence to any district out of Lusaka, or maybe organizations, will they be required to declare the HR personnel to the committee? I guess this is about declaration of details that may be considered important. I think we dealt with this during part 3, but the question has arisen. Who would like to take it?
Yes, thank you so much. Generally, our area discussion alluded to the fact that there are fundamental changes. But then what the law has said is that it has given us the privilege to prescribe any other requirements in changes. And from where I sit here, a change in location, because of what we've been discussing, is very cardinal. You remember we were setting up certain committees to take justice to the districts where people are. So in case you move, you are in Lusaka and we had put you in Kalabo, for instance, you will no longer serve that purpose. We wanted you to be in the district. At that point, you must be replaced. So that change is very cardinal to us. We must be notified. And we have seen from the law that within 7 days of such changes, we must be notified. And again, as an ambassador of Glow Up or modern technology issues, I will emphasize. That's why we have made it easier through Glow Up and other social media. You can input that change from the comfort of your home or your office. Just say I've moved from here and here, then we'll capture it from the system. That's how easy it is. Don't wait to post and the letter reaches us 2 months later. Thank you.
All right, thank you, Registrar. A follow-up question says, I've checked for the documents on the website, but I can't find them. So I want to suggest that the person who's asking is the officer. Probably somebody from the Secretariat can contact her and just provide the support that is required there. Thank you so much. We will now move to.
Before we move,
Hi.
yes.
Yes.
I also just wanted to remind practitioners. I'm suspecting that we have some new practitioners joining us for this webinar. But what we have been saying, even right from the annual general conference, is that the law is out, but that's not the end of the work. There's still a lot of work to be done. There's still a number of SIs that needs to be promulgated. Some of those SIs will relate to how to register, how to do certain things that are required of practitioners in the law. Those forms that will be part of the SIs have not yet been promulgated. So if people are already going onto the website to look for them, I think the important message to give out to the members is that those forms are not yet in place. It is work in progress, and then they should look out for those new developments on the website in due course. Thank you.
All right. Thank you. Thank you so much, Council. Thank you so much. All right. So we'll move now to the last part for the day, which is part number 5. And this part looks at the inspectorate. Now, this is a major change. Now, this is a major change because the Act of 1997 did not have an inspectorate. This Act, introduces the inspectorate. Just in a nutshell, what does this part talk about, and what is the role of the inspectorate? Council Mujuda, maybe you could lead us in that discussion.
Thank you, CS. And I think for me, I think this is a very important part 5 for the Act. I think compliance is very important. I think to have the Act is one thing, but compliance is another thing. I think if we are going to put all the things that have been put up, especially when it comes to registering of practitioners, exhibition of people's certificates in the offices, where we're going to have people who are not qualified to be practitioners, but they are operating. This is where now the real issues can come in. And this, the Act provides for the appointment of these inspectors who will go into the offices, make random checks, or in the event of maybe you heard the registrar talk of whistleblowers. Once they receive information that there's somebody in company X operating or is a foreigner without a practicing certificate, the inspectors will be able to go into these companies and check. These are inspectors will be appointed by council. I believe these are going to be members of good standing who will be on a voluntary basis, or what will be able to go into these companies and conduct the random searches. They will have the ZIHRM identifications. Of course, when they go into these companies, they would have to go there with a warrant to show that they do have authority to go and conduct those searches, which it means that these searches will be conducted judiciously also to ensure that the rights of the persons who are being searched are observed and that they operate above board. So during our annual general meeting, I did give an example of how ZIHRM inspectors operate, and having worked in the private sector, I have witnessed how ZIHRM inspectors would land on a company. I just envisage that that is kind of a scenario that you might see that these inspectors might do. They will come in and announce. And remember that the Act, it also allows them to collect certain documents. They could even seize computers to check. But of course, once they finish that exercise, they're supposed to return all those things. So if you've witnessed how ZRA inspectors operate, I believe that might be the extent to which these inspectors would be operating. But main is to ensure that there's compliance. Thank you. Maybe Council Olaya could add further on that. Thank you.
Yes, my addition would be to state that these ones will not be operating on a voluntary basis. And to sort of buttress my position, let me give you some justification why they should not operate on a voluntary basis. Volunteers normally are those people who have a lot of passion, they have a lot of time, they are retirees. You might not get a lot of them. So what you need is people who will be employed by the Institute to carry out this particular function. If you look at Part 5 of the Act and the powers that are given to the Inspectorate Unit, these will be the teeth of ZIHRM. Apart from regulating practitioners, which is what they had been doing, albeit on a voluntary basis before, the one thing that ZIHRM was not able to do effectively was what Part 5 is doing, all right? So these inspectors can enter onto premises, can search, can remove items that they consider will be necessary for evidence, almost similar to police powers. So you don't want volunteers. You might have a few, you know, to help out, especially in certain areas where you might not have a lot of, you know, money to equip, you know, each particular province, say, to go and inspect. You might have some very, very esteemed practitioners there who might be able, whom you might give this inspectorate power to. So they would have certificates also to show where people, wherever they are going, who they are representing, and the sort of powers that they have. So this is a very, very important part of the law. You will even see that it's actually an offense to obstruct an inspector. There's actually, let me just get the actual fine. So you could actually be fined an amount not exceeding 300,000 penalty units. Multiply that by 13 way or 0.3 so that you get the kwacha value. Or you might go to prison for a term not exceeding 3 years, or depending on how bad you are, a judge can actually give you both the fine and the prison term. So you can't impersonate an inspector. You can't give the inspector false information. You can't obstruct them in their work. So it's very, very serious penal powers that are given there. And yeah, so for those of you who have worked long and you want perhaps a change of job, you might apply when the Institute advertises for inspectors. Thank you.
Thank you so much, Council. So in accordance with the provisions of Section 49(1), an inspector may, for the purpose of enforcing the provisions of this Act at any reasonable time, without prior notice and on the authority of a warrant, enter any premises that the inspector has reasonable grounds to believe is used for the commission of an offense or contrary to the provisions of this Act. Does that mean that every time an inspector needs to go and inspect a premise, that they must have a warrant? Or does that mean that there will be times when an inspector might need a warrant and times when an inspector might not need a warrant? I would like to get your interpretation of that. Maybe let's start with Council Mujuda, and then Council Olaya could comment as well. Sorry, Council, you are on mute.
I'm just looking at this provision.
Yes.
Without prior notice and on the authority of the warrant. So from my interpretation is that it would have to be without prior notice, yes, at any reasonable time, yes, but with authority of the warrant. That is my take of this.
Okay. Council Olaya, your thoughts?
Hi. So the issue here will be how to interpret what a reasonable time is. Now, whenever you see these words in the law, it means we are going to use the judgment of an ordinary sensible person. So it might be any time during the day. It might even be in the night in certain industries. So normally, we would rush and say a reasonable time might be any time during the daytime. But what about if it's in a sector where their ordinary hours of work are normally in the night? All right, or they have shift work and this particular issue that you need to verify is in the night. So in that particular sector, it might be reasonable according to the practice, of that particular sector to work in the night, to have inspectors going out there in the night, like happens with ZRA, before the ban, for trucks moving in the night, trucks used to move every every hour of the day, every hour of the night. And then you get a tip off there's a consignment of some illegal contraband. You will not say, no, how will it look if we go in the night? If you go in the daytime, you might miss the opportunity. So what will be a reasonable time will depend on the circumstances of each case. Without prior notice, as Council Mujuda has stated, means just that. You just need to go to a court and tell the court you have a reasonable suspicion. They'll give you a warrant. That is what will enable you to actually search the premises and search the person. Whenever you see issues of a warrant being introduced, this is where the law is trying to balance the interests of the profession, the public policy side of things, and the rights of the individual, their rights to privacy, the right to their person, not to just be searched anyhow. But when a warrant is given, it then gives a person lawful access to infringe on another person's person or another person's property, so to say. Thank you.
All right. Registrar, would you want to comment on that provision as well before we move? Registrar, are you there? Okay. All right.
CS,
Hi.
you were cutting. I couldn't hear clearly.
Sorry, I was asking whether you wanted to also comment on the provision that we're just looking at, section 49, the one that talks about on the authority of a warrant or giving reasonable at any reasonable time or without prior notice, an inspector can search premises. And I just wanted to get your interpretation of what it means on the authority of a warrant. Does that mean that every time an inspector goes out to inspect a premise that they must be able to present a warrant? Or is it possible that they can call and tell them we want to come and inspect your your premises, and based on that, they're able to have access to the premises.
Thank you. Law is what it is. Wow. You could, if the other one was supporting council, the other one was opposing, you could hear so many views. Yeah. Okay. What I've done is to differentiate the issue of inspections enter into a premises for the sake of enforcing this act, and going into the nitty-gritties of at what point do I want to search a person. Two different things. Inspections in 1 and 48, section 48, 1 and 2, for issues of inspections entering to check compliance of these membership issues. What suffices is your identity card. This principle is gotten from labor inspectors. I know behind what happened here. So you are a labor inspector, for instance, before we talk of the ZIHRM inspector. When you are appointed as such, and I think they renew annually or so, or in 2 years, whatever the case is, a card that when you come to a premises to enter and inspect suffices to make you enter. That's that ID. And this is what we'll do. We'll issue all those that we employ as inspectors, those IDs. Then they will allow them to enter premises in reasonable times as explained and inspect. Going beyond doing certain other things which will entail invasion of privacy. I want to specifically talk of personal privacy. Like I want to search you where the law has specified if you are female, you must be searched by female. When it reaches there, you can't just grab someone. You need a warrant. You can't grab someone, whether you are female, say immediately to search, and then you start dipping into, no. That's where you need a warrant, because you would have crossed certain lines that must not be crossed in privacy. And if you look at section 49.2, also, you being a person, you look at certain reasonable grounds which will warrant you as an inspector to apply. So at 49.2, a court may issue a warrant on application by an inspector if it appears. So there are situations which will prompt an inspector to apply so that the court issues a warrant. So twofold, this question. It's not every day when I stand up, I want to go inspect in the field, then I rush to court and bring a warrant. No, there are certain issues that hinge on rights of other people. Whether they're in the wrong, you know that. And that will want you to apply for a warrant so that you are within law. What it simply means when it gets to that extent, you are infringing on people's rights, but those rights are infringed legally. Because if I'm touching into your bra or whatever, I'm infringing on your privacy right. So it must be done legally. That's my take on this one. Thank you, CS.
All right, thank you so much. We move on in the discussion, unless the two discussants have reaction to what Registrar just said. All right, let's talk about the rights that an inspector has. when they have a warrant. To take extracts from or make copies of any book, document, or record that is on the premises and that has a bearing on an inspection or investigation, demand the production of and inspect relevant certificates, and make inquiries that may be necessary to ascertain whether the provisions of this act or any other law on which an inspection or investigation is based and have been complied with. Let's say an inspector needed to review information that pertained to certain, compensation related issues in trying to look at adherence towards, let's say, eco pay and eco work related provisions. Is that something that firstly an inspector would be expected to be able to cross in this particular sense? And secondly, in the event that certain information is held or rather hosted on, let's say, a cloud based system that may be hosted outside the country, what would be the obligation of an organization that is being inspected in that particular time in ensuring that they are compliant with the warrant that the inspector could have or the mandate that the inspector could have? Comments around that? I'm not sure who would be very keen and comfortable to begin the response. I'll leave it open to any of the discussants. Anybody? Council Mujude, I can see you unmuting.
I don't know the example you've given. If the inspector is going to find information such as the eco pay and what, I don't think that would be maybe the issue that the job of the inspector in that case. I think it would be. I don't think that would be under the mandate of the ZIHRM, and I think issues of pay would be contractual issues. Probably that would fall under the labor commissioner who would get to that. From my take of the inspectors, would be really to see if there's contravention of the act, the ZIHRM Act. This is unlicensed people or people masquerading as practitioners. Remember, the inspectors would be expected to gather information, which information could be used in the prosecution of such persons. The Act has provided for offenses that people would face. So if somebody was going to masquerade a practitioner, it's that kind of evidence that they would need to enforce that. That is my understanding, and I don't think to check on issues of equal pay, I don't think that would be under the mandate provided. I submit.
Okay. Council Ulaya, any comments there? And maybe in addition to the example given earlier on equal pay and equal work, let's say there's a process around recruitment and a practitioner has made a submission to, let's say, Department of Immigration, that they have gone through a recruitment process and were not able to find a candidate that was meeting certain skill requirements within the country, and so they're making an application on behalf of an employer to engage an expat employee, for example. Would an inspector, for example, have right to, an inspector under this act have right to investigate matters like that? Investigate matters in the to the extent, for example, of whether the recommendations made by a practitioner towards employment conditions are compliant with the law, or whether certain applications that the practitioner may have made on behalf of their employers or directors are in compliance with the provisions of the law. Maybe let me expand the question a little bit more without restricting myself like I did, I think, when Council Mjuda took the question. Council Laya, your comments, maybe Council Mjuda, if you'd like to come back on what your response was, and registrar, you could comment as well. Councillor, are you there? Okay, looks like we may have lost her. Registrar, would you like to comment?
Yes, thank you so much. The starting point is the definition of HR, the constitution of professional misconduct. You will know that certain matters requiring investigation will dwell on if misconduct was through recruitment, for instance. You will need some documents if you are asking questions around that. If I was trying to look through a particular function on advisory on other labor laws. So from that context, the search is not just about I enter, where's the certificate, the practicing certificate is here. Then, oh, okay, we are good, we go. No, the serious matters. Mind you, also, we're talking of other governance documents. For instance, competence framework. If I'm inspecting you thoroughly and the other governing documents have said an associate shall possess this and practice at this level, I come to you of suspicion that you are practicing wrongly. You need to prove that. And so I'll need documentations to do that. Even in the old regime, I'll tell you a scenario. We went to a company in Copperbelt. We were with the former minister then, Madam Simukoko. It was reported to us that the HR was not actually qualified and they had done something else. So when we entered, we demanded to see their file and what their qualifications were. We discovered that that gentleman was a mechanic doing HR. The minister was so angry that she ordered that he be chased from the premises. Save we said yes, but there are a bit of processes, but he shouldn't be anywhere in HR. What are you doing as a mechanic in HR? So those are instances we're talking about here. You will require certain documentations for certain things, not specifically to end at what is your practicing license, what is your number, then you are done. No, we'll go further than that, and that will require documentation, which you must bring, except if we want to take away such documentation, as the rules are everywhere, and the law has followed suit that you need a receipt for it when you are taking away. If I'm within the premises, I've demanded to see and check this, I'm within the rights, and that should be done. But at the point where you know the rule of taking, it's just an inventory to show what you've taken, some of it will be required to be returned back. And there's a tendency, you can refuse later to say, no, I didn't take this. Even the bailiffs, when they come, whatever they take, they will list, there's an inventory to show that this has been taken. Even when you do your stay and whatever, they are returning your property, it will be compared to what was taken. So that's my take on that. Thank you.
All right, Councillor Laya, are you there? All right. Do you have any reaction, Councillor Mujuda, before we move? Okay, all right. All right, thank you so much. With that said, just take a few more questions before we wrap up. I think we've talked about issues around what the fines are for obstructing an inspector. We've talked about the power of entry and search of an inspector. And I think we've also glossed briefly on who will be, which kind of people could be appointed as inspectors. Is it just employees, or is it people that may not be employees? The law does not prescribe that these persons must be employed, but that they must be appointed. And so I think with that, we almost have exhausted the provisions of Part 5, but very quickly, I can see we have a question here that maybe we could try and apply ourselves to. The question says, greetings, could you be kind enough to advise qualifications of an HR/talent manager in any given corporate firm? Would we have a response to this question, Registrar?
Thank you so much, CS. As regards to qualifications in HR, currently, as I indicated, that there's more refinement coming. But in the absence of that refinement, we have used the standard booklet, which we have, I don't know whether, yes. It has been with us. I think members would remember this copy. This is the standard booklets that we use, and it's been adopted by the instructors. So in this standard booklet and other documents prescribing qualification to membership and to practice as HR currently, you will know that pure HR trained, be it your diploma, your degree in HR, then the standard booklet has allowed related social sciences. And in practice, we've seen that public administration, business administration, management, industrial psychology, they've been accepted to be part of the qualification for one to be licensed as HR. You will note also that for other things like talent management, training, and all those, according to organizations, when they are recruiting, they will need someone maybe who've done training and whatever. That will be their prescription. But in terms of registration here, this is what the standard booklet has said. Until when it is revised, this is what is pertaining now. Thank you, CS.
All right, thank you so much. Right, Council Laya says she's blocked from unmuting herself. IT, can you please assist to have unmuted? All right, we've come to almost the close of our session today. We've been looking at part 4 and part 5 of the ZIHRM Act, and we still have, I think, a few minutes. If there's any question, very quickly, we could take a question. If not, I will just ask that we could have the final words from our discussants today, and then we will close and then make quick announcements around what the next session is going to focus on, so that you can prepare accordingly. Councillor Mujuda, would you like to give your final words for the day?
Can you hear me now? I've now been allowed to unmute.
Yes, we can hear you.
Okay, thank you. So just to say that the act is in force after being signed by the president on 8th April. And I think people should be conversant with this act. I think they shouldn't say you were not told. I think it's very important that you treat this, this is your career, and you need to, if you really cherish your career, you ensure that you follow what is stipulated in this act. Otherwise, you may end up having yourself the student, but you may have to switch careers because the act is very clear, very serious, and you would also want to acquaint yourself with section 53 of this act, where I say there's no hiding place from this act. You will find that you might be held liable as a practitioner if you go and misconduct yourself in Botswana. You bring ZIHRM into disrepute, actions might be taken against you. But all in all, I think it was a pleasure interacting with everybody during the 3 webinars we've had. Thank you, Chair.
Thank you so much, Council. Council Laya, you're both on mute now. Right, Registrar, maybe you can come through as we still get to see how we can assist Council Laya.
Thank you so much, CS, and everyone else listening in. My concluding remarks will be that I encourage, under this part or these 2 parts we've looked at, our practitioners out there to conduct themselves professionally. It is never my desire to see any practitioner be in trouble with the law. However, that choice is in your hands. When you are found the other side, even if it was not our desire, we ensure that the law is applied without fear and favor. That's the first part on professional misconduct. On part 5, my emphasis is that, ladies and gentlemen, make no mistakes to obstruct my inspectors out there, to cause them delay when they come to execute their functions under this act. There, I will not compromise. We shall visit you with the law swiftly. So our request is comply with the inspectors. If you are to make good properly, not with arrogance to stop inspectors in conducting their duties. There we shall not compromise. And as you've seen the penalties there, they are very stiff. Don't delve into those waters. Thank you so much. It's been nice interacting with you. Those other questions that we haven't been able to attend to, if there are any, reach us at any time. Our doors are open. We will address them. Thank you so much.
All right, thank you so much, Registrar. Council Laya, you're having any joy now? All right, looks like we're not winning. And so unfortunately, we will not hear the final submissions of Council Laya. It would have been good to be able to get to hear a final comments from today's discussion. But ladies and gentlemen, allow me to thank you for your time. Allow me to thank you for continuously following these discussions. We almost concluding this series. The final
Okay.
session. Okay. All
Chair,
right. Please.
finally.
Yes.
Finally. I mean, this would have been such an anticlimax. Huh?
All right. Let's give you a little bit of time to comment before we close.
Yeah. And what words did I want to end on? Okay. So we have dealt with what appears to be is it the headmaster part or the prefect part of the act, and it does sometimes tend to get a bit scary, a little bit intimidating. You know what I mean? Like you might be sitting there as a practitioner and thinking, oh my God, what have we brought onto ourselves? I just want to give you some assurance. I have been a practitioner for close to 20 years. September 27th this year, I will have clocked 20 years of good standing at the bar. All right? If you ask me, I have got no clue what the section is on misconduct in the Legal Practitioners Act. What I strive to do every day as a practitioner is to live by the principles of my profession, to do everything in good faith to the very best of my ability and my judgment. And that way, you will not come to a situation where we are now beginning to quote certain sections of the law on you. So this particular provision is just like I had said at the beginning, it's supposed to be that thing that is at the back of our minds to shepherd us onto good behavior. And it is my sincere plea and hope that none of us will ever be found on the wrong side of this law, because I think the repercussions are quite dire. It's really not worth it. You might perhaps want to take up another profession as a bricklayer or as a plumber, but honestly, what person will even want to hire you to fix their toilets if you could not fix, straightforward things, So as part of my last words, since this is our last webinar, is it not? Do we have one more? Okay. Last but one, yeah. It's to encourage this good behavior, because that is what this law is about. We want to, improve the esteem of the profession. We need to get the right people in these spaces, so that we have very, very little industrial unrest, industrial disputes, and disturbances, which ultimately affect productivity of this nation. If we are going to be a competitive nation, if we are going to attain Vision 2030 to be a prosperous middle income country, we are the engine as HR practitioners. And this particular provision is just to help us remember, if you decide to get tempted, if you decide to get lazy, if you decide to, slow down on your ethics, this particular provision will visit you, and we don't want that. So I thank you again, ZIHRM, for giving me this opportunity to be a partner with you in education of education and information dissemination for our practitioners. And I look forward to being with you again in the last webinar, is it? Or many more to come. Incidentally, Ziale has gotten in touch with me. I will be doing a labor course with them from 18th July to 29th. Let this be the last course I am doing with Ziale, all right? The next time I'm getting an invitation to go and lecture on labor law, let this invitation come from ZIHRM. I beg you. Thank you. That's money that is going to the lawyers. They are fast. They don't play with money. So start loving money like that also. Thank you.
All right. Thank you so much, Council. We appreciate your time. Thank you so much, Council Mujuda, as well. We appreciate your time. Thank you so much, Registrar. We appreciate your time. You've been excellent discussants. And to our, members, the video recordings for all these sessions are available on the website. So in case there's colleagues that have missed all the sessions, please encourage them to visit our website and they'll be able to catch up with what they've missed. And if they have any questions whatsoever, we have a group on GlueUp that's dedicated to questions on the Act. So feel free to be able to post your questions there, and you will definitely get your response as to what the provisions that are in the Act mean. And if you need any support whatsoever in sensitizing, your staff in HR or even senior management within your organizations, feel free to reach out to the Institute and invite that the Institute comes to make a presentation in your organization. We can help you to tailor, the conversations or, some messages that would basically speak to certain, issues that might need to be addressed. We've already received invitations from a number of organizations, and so far so good. And we hope that we can engage with more, corporate organizations out there to ensure that we can build the compliance in the way that we need to be compliant with this law. Thank you so much on behalf of the 14th Council. We want to thank you for your interest in the developments in the profession. This is how we move forward as a profession. We understand what is happening around us. We appreciate the context. We appreciate the opportunities, and we move forward together in shaping what this profession must be known for in the future. Just to recap, we have the process of reviewing the constitution ongoing at the moment, and so look out for communication around how you could participate towards a process. We have the process of reviewing the code of ethics ongoing at the moment. Look out to how you could participate in that process. We have the process of reviewing what should go into the SIs that are required and provided for under this act. And so make your submissions as well when called upon. And lastly, we have efforts being put together as well to be able to shape what will be known as a competence framework for the institute. The questions that you may have around, if I'm going to be director in this particular organization at this particular level, what kind of competencies must I have? All those questions are going to be answered through these interventions that the institute is embarking on at this particular stage. This is our institute. It therefore becomes our duty as members to ensure that we've shaped it in the way that we must. The Act gives us a lot of leeway to ensure that we've taken advantage of the provisions that are there, and to ensure that we've also taken advantage of the value that we can bring to the table to be able to shape the future of this particular institute. And so please make time for the last webinar, which is going to be held soon. Look out for communication soon. And the last webinar is going to basically focus on the last part, which is part number 6. And then we'll also look at any issues that may have come up as issues of debate or heavy discussion on the groups as well as in other forums, and we'll try and shed clarity on all those issues. So for today, thank you so much, and we look forward to seeing you again soon. Enjoy the long weekend, and hope that you can have some beautiful time with your families. Thank you so much.
Thank you. Thank you very much. Pleasure.